Hey guys, welcome to Apex Agent. Today we're going to do another 25 quick practice test questions you will find on the exam. Let's see here. What topic do we want to do today? Let's do encumbrances, liens, title transfer, and recording leases. All right. An important part of the transaction is obviously the title work, the middleman making sure there's no liens on the deed, getting you a fresh, clean deed, and making sure that the boundary lines are good and everything for the transfer. So let's start. Which of the following describes an encumbrance? A third party's right to encroach upon a property without the permission of the property owner. A third party's right to claim the sale proceeds of a property that has been mortgaged as collateral for a loan. A third party's interest in a real property that limits the interest of the freehold property owner. Another's right to acquire a freehold interest in a property against the property's owner's wishes. So, figured it was that one, but I just clicked that one. Third party's interest is a real property that limits the interest of freehold property owners. An encumbrance is an interest in and right to real property that limits the legal owner's freehold interest. In effect, an encumbrance is another's rights to use or take possession of a legal owner's property or to prevent the legal owner from enjoying the full bundle of rights in the estate. Let's simplify this a little bit. Actually, let's do a real life example. Encumbrance is when someone else has a legal right that limits what you can do with your property, gives them certain rights over your property, affects your full ownership rights. Think of it like this. Even though you own the property, another party has some control over rights over it, similar to having a claim or restriction on your property. Simplify this for a minute. One more time. Actually, just make it into quick tips for the exam. Remember that encumbrances limit the owner's rights. Look for keywords like third-party interest and limits. Think of encumbrances as claims or restrictions on the property. Avoid options complete property takeover. It's not complete property takeover, it's just a partial rights. All right. That was a long one for the first one. Let's get going. In executing a condominium lease, a tenant has acquired a temporary transfer of legal title, a limited freehold interest in the airspace of her unit, a temporary possessory interest, a title conveyance in exchange for rent. I think it's temporary possessory interest. That is correct. A lease is both an instrument of conveyance and a contract between principal parties to uphold certain covenants and obligations. As a conveyance, a lease conveys an interest called the leasehold estate. It does not convey legal title to the property. For this reason, a leasehold is also called less than freehold estate. So lease, they actually have quite a bit of rights once you get a lease. You can't, you got to look at the contract, but they actually do have quite a bit of rights as tenant rights. So again, they have a possessory interest in the property. Broker Yvonne successfully closed on her listing, but the seller refused to pay the commission. What is one of the legitimate course of action available to Yvonne? A vendor's lien, an intangible lien, a broker's lien, a mechanic's lien. Let's try broker's lien. Many states allow a broker in specified circumstances to file a broker's lien against a property following the closing of a transaction. Here, the party who is obligated to pay the broker a commission refuses to pay. The broker's lien, once filed, attaches to the real estate interest owned by obligated party. So again, broker Yvonne. So it's a broker's lien. Under landlord-tenant laws, landlords must treat tenants fairly and honestly. In a residential leasehold, this requirement would include ensuring the tenant against loss of personal property, providing required building support and services, guaranteeing that a fair rent is being charged, ensuring the property for the value of the leasehold. The residential leasehold this requirement would include. Yep. The lease defines a landlord's obligations, so every lease is different, but most of them principally are to provide the necessary building support and services and maintain the condition of the property. It is the tenant's responsibility to obtain insurance and to determine the fairness of the rent. Renter's insurance is only like 20 or 30 bucks a month. Always recommend you get it if you do have, if you are a renter. An encroachment, an easement that has not been recorded on the title of the burdened property, an unauthorized physical intrusion of one property into another, a right granted by a property owner to the owner of an adjoining property to build a structure that protrudes across the property boundary, a structure that does not comply with zoning ordinances. So an encroachment I know is over the lines, an unauthorized physical intrusion of one property into another. So an encroachment, this is a right granted by a property owner to the owner. So it's not, this happens when somebody just throws a fence up and it's 5 feet over the line. That's an encroachment. Somebody puts a shed on your property and the back end of it is on the other person's property. It's an unauthorized physical intrusion. An encroachment is the unauthorized physical intrusion of one's owner's real property into that of another. Examples of encroachment are a tree limb extending into the neighbor's property, violating his or her airspace, a driveway extending beyond the lot line into the neighbor's land, and a fence built beyond the property line. So this also includes like the trees, if there's branches over the other person's airspace, I guess that's an encroachment as well. To be marketable, a title must be insured, free and undisclosed defects and encumbrances, abstracted by an attorney, guaranteed by a title certificate, free of undisclosed defects and encumbrances. Marketable title, by definition, one that is free and clear of undesirable and unknown encumbrances, claims, clouds, or other defects. Attorneys' abstracts and title certificates do not guarantee that a title is marketable. So, free of undisclosed defects and encumbrances. I mean, I think a title certificate would be that, but we'll move on. If someone has used a private road across another person's property for 15 years without permission and meets all statutory requirements, what might they acquire? A prescriptive easement to use the road, ownership of the entire property, an easement appurtenant benefiting the land, a license to use the property temporarily. I think it's a prescriptive easement to use the road. I don't think it's ownership of the whole property. Let's see. Yep. A prescriptive easement can be acquired through continuous, open, and notorious use without permission for a statutory period. It grants the right to continue using the specific part of the property. So the ownership of the property is usually when it's used in like the whole property. Some people have done that and gone after somebody for taking care of the property for a certain amount of time. This is just a road they were using back and forth. So don't let it get, confuse you there. It's just a prescriptive easement. Brian enters into a lease agreement where he pays rent plus a portion of the property's operating expenses. This is an example of which type of lease. Lease agreement where he pays rent. In a net lease, the tenant pays rent along with a share of operating expenses such as property taxes, insurance, and maintenance. Net lease, let's break this down a little bit. A net lease, tenant pays two main components: base rent, share of operating expenses. Operating expenses include property taxes, insurance, maintenance costs. So net lease is the one that you have to two different parts. I believe gross lease then is just the one payment. So net lease, two main components: base rent and operating expenses. Again, net lease. If an owner of real property dies in a state and has no legal heirs, what will happen to the property? It will escheat to the state or county. So this escheat just means that the state takes it when there's nobody left. I remember that and didn't have to look at the rest of them. Escheat, if an owner of a real property dies and has no legal heirs, so the state takes it over if there's nobody there to pick it up. The estate escheats or reverts to the state or county after all claims and debts have been validated and settled. A property is secured by a mortgage that does not contain a power of sale clause. To foreclose, the lien holder will have to file a deficiency suit, file a foreclosure suit, file a suit to quiet title, obtain a quiet claim deed. I believe it's a deficiency suit. Foreclosures. I should have known that. To foreclose, it'll need a foreclosure suit. Stupid. Judicial foreclosure occurs in states that use a two-party mortgage document, borrower and lender, that does not contain a power of a sale provision. Lacking the provision, lender must file a foreclosure suit and undertake a court proceedings to enforce the lien. So to foreclose, you need a foreclosure suit. Just remember that going forward. Scenario: Mike has been parking his car on an unused portion of Alice's property for over 15 years without her permission. Alice is aware but has never objected. Which of the following legal outcomes might Mike claim if he meets all the statutory requirements? Mike could acquire a prescriptive easement, allowing the, I just went through this, allowing continued parking. So there we go, remembered it. 15 years without a permission, prescriptive easement. So just think of the property there. They're prescribing an easement to it. After Jane's property was foreclosed, she learned that her state provided a statutory redemption period. How does this benefit Jane? It allows her to buy back the property before foreclosure. It permits her to clear the deficiency by paying half the mortgage balance. It allows her to reclaim the property within a set time period after foreclosure. It forces the lender to renegotiate loan terms. I believe what this is statutory redemption gives her a time period that she can get. Yeah, a statutory redemption period allows a foreclosed homeowner to reclaim the property by paying the foreclosure sale price within a specified time after the foreclosure sale. A tenancy at will can usually be terminated by, I believe, just either a party giving property notice because they're at will. Yeah, there's nothing forcing them to be there. Um, so at will, just think other property can give notice and be done with it. In the absence of an explicit term with beginning and ending dates, a court will generally construe the lease to be tenancy at will, cancelable upon proper notice. Which of the following best describes a mechanic's lien? A lien against real property owed by a debtor, a specific lien placed on a property by a contractor or builder to secure payment for services provided, a voluntary lien used to secure financing from a bank, a general lien that applies to all future real estate acquired by the debtor. So best describes a mechanic's lien. Just think of them. I don't know why it's like not a contractor's lien and it's a mechanic's lien. But just think if they're doing work on your house. So it's a specific lien placed on a property by a contractor or a builder. A mechanic's lien is a specific lien that can be filed by a contractor, builder, or other provider of services or materials to ensure that they are paid for work done to improve the property. There's actually a question on the disclosures actually that covers this because if somebody's just got work on the property in the last 30, 60 days, let's say, and they go to sell their house, somebody might not have gone after them yet and put a mechanic's lien on that. So they try and get to the bottom of that before it actually goes through. There's a time lapse there. So we'll sometimes see that if the work's been done like within 60 days and it's not paid, then it catches up while we're under contract. They see it's under contract, and then they go after it. So that's what a mechanic's lien is. It's somebody who does work on the house typically and then doesn't get paid. Which of the following happens when a leased property is sold? The buyer acquires title subject to the lease, which remains in effect. The lease is canceled. The lease expires within 30 days unless renewed. The new lease is automatically executed. So when I said earlier that the leases do have power, those leases typically supersede sales contracts because they have a tenancy. So you have to let them, if they're month to month, you can terminate obviously when the time comes. But the buyer acquiring title is subject to the lease, which remains in effect. So you can't just break a lease, they can sue you for that. So the landlord may sell, assign, or mortgage the leased fee interest. However, transferring and encumbering the leased property do not extinguish the obligations and covenants of a lease. Buyers and creditors, therefore, must take the respective interests subject to the terms of the lease. So whenever we sell investment properties, people always ask for copies of the leases so they can see how long they're in effect and see the terms. A break in the chain of title to a property results in a clouded title, a title plant, a lien of indeterminable ownership, a duplicate title. So I believe it's a clouded title because you can't see the title steps perfectly. So just think clouded, like you can't see the whole thing perfectly because there's a missed step somewhere in there. Chain of title refers to the succession of property owners of record dating back to the original grant of title from the state to a private party. If there is a missing link in the chronology of owners or there was a defective conveyance, the chain is said to be broken, resulting in a clouded title. So just if it's not a clear, good title, just think clouded, right? All right. Kevin defaults on his mortgage and the bank initiates strict foreclosure proceedings. Which of the following best describes strict foreclosure? The lender immediately evicts the borrower upon default. The lender files a claim to take title directly without a foreclosure sale. The borrower may redeem the property by refinancing a loan. The property must be sold at auction. Proceeds go to the lender. Kevin defaults on his mortgage and the bank initiates strict foreclosure proceedings. Which of the following best describes strict foreclosure? I'm going to go with sold at auction. Wrong. Lender files a claim to take title directly without a foreclosure sale. So strict foreclosure proceedings, just think there's no foreclosure sale. They just take the title over. Strict foreclosure proceedings means there's no sale, there's no foreclosure. Strict foreclosure means they just take it. In strict foreclosure, the lender files a claim with the court to obtain title rather than selling the property at auction. The process is used in certain states where a foreclosure sale is not required. Strict foreclosure, there's no sale. A municipality wants to build a sewage treatment facility which will require acquisition of several parcels of privately owned land. What legal power enables the municipality to buy the necessary properties even against the owner's wishes? Estoppel, escheat, alienation, eminent domain. So eminent domain, just think that domain is like a house. So they're acquiring the property imminently, immediately, right? So the domain, just think of it as the property. Imminent means they're taking it immediately. Various government and public entities can transfer private property to the public sphere by the power of eminent domain. The transfer is involuntary even though the owner receives compensation. For example, a city government wants to widen a highway to accommodate growth. The government uses eminent domain to condemn and purchase all properties abutting the thoroughfare in order to complete the construction project. So typically they do an appraisal on them, they don't just take them off to the streets. They'll do an appraisal on it. There's a process, takes a little time. And so they're just throwing people on the streets, and bulldozing their houses. There's a process. They do an appraisal on it. They get an accurate value of all of them, and then the state actually buys those from them. Is how it works. So eminent domain, it's domain. Taking your home is imminent. So, during a probate proceedings, the court transfers a descendant's property to the legal heirs. What type of title transfer does this represent? Voluntary alienation, involuntary alienation, public grant, quitclaim transfer. During a probate proceeding, the court transfers a descendant's property to the legal heirs. I'm going to go with quitclaim transfer. Wrong. Involuntary alienation. Quitclaim transfer means they just transfer it real quick and don't check anything. Involuntary alienation. Probate transfers property according to the state laws of descent and distribution of the descendant's will, making it involuntary alienation. Let's see simplified. Property transfers through probate court are not by choice. Probate court, not by choice. Okay, so this isn't an estate, it's in probate court. The court must follow state laws, descendant's will, if it exists. The heirs receive title through legal process. The transfer happens regardless of the deceased current wishes. Key point, since property owner is deceased and cannot voluntarily transfer the property, it's considered an involuntary transfer by law. I think that's usually mean when it's not set up like in an estate, because then the estate dictates what happens to the property. So probate court will probably look at it and figure out what happens involuntarily. I'm not sure where the alienation comes into it, but involuntary is probably what you want to take away from that. The court's taking care of it. It's not voluntarily decided. To make a successful claim of adverse possession, the adverse possessor must satisfy which of the following criteria? The possession must have been concealed without permission and for a statutory period of time. The possession must have been unconcealed for the necessary length of time and without permission. The possession must be with intent, secretive, notorious, and hostile. The possession must be open without permission for the statutory period of time and within the number of permitted intervals. To make a successful claim of adverse possession, the adverse possessor must satisfy which of the following. So adverse possession, I think, is the one where they're taking care of the property for years and then decide to take it. Possession must have been concealed without permission. No, possession must have been unconcealed for the necessary length of time and without permission. Possession must be with intent, secret, and choice. Possession must be open without permission for the statutory and within the number of permitted intervals. Adverse possession is only possible if possession is open, continuous for the statutory period, and the possessor claims ownership. So that is basically, so I'll give you an real life example. I had a boss one time, he had hundreds of acres, and he let his neighbor use 5 or 10 of his acres just to kind of feed their cows and got the grass down, and it helped him feed his cows. Now, after about 15, 16 years, the guy said, I'm going to take that property because I've been taking care of it now for X amount of years. And the court successfully gave him that property. The man was very upset. Let's just say there was words spoken and everything outside of court. But that is a real life example of adverse possession. So they needed, and he was given permission to use that. So it's not like you're just trespassing and taking care of something. There was permission given for X amount of years, and then they went to the court for adverse possession. Which of the following is true of easements in general? They involve the property that contains the easement and a non-owning party. Choose maybe that one. They apply to the whole property, not to any specific portion of the property. They only involve the legal owner of the property. They may require specific use, but cannot prohibit one. I believe it's they involve the property that contains the easement and a non-owning party. So a lot of times there's a utility easement, right? 5 feet in your ground, there's an easement from the government that they have that they can put utilities right through your property. So that involves the owner that has the easement, and a non-owning party would be the government. So an easement is an interest in real property that gives the holder the right to use portions of the legal owner's real property in a defined way. One cannot own an easement over one owns property. Easement rights may apply to a property's surface, subsurface, or airspace, but the affected area must be defined. So same thing when they were using the driveway for 15 years. That was an easement. And then after 15 years, they made it as part of their deed saying it's a prescriptive easement. Almost done. John's home was foreclosed and the sale of the property did not cover the remaining mortgage balance. The lender is now seeking court order to recover the shortfall from John. What is this type of court order called? This is I already know this, a deficiency judgment. So when they try and satisfy the loan and they don't, there's a deficiency balance. That balance becomes a judgment and it's a deficiency judgment. A deficiency judgment allows the lender to recover the remaining debt if a foreclosure sale does not generate enough proceeds to satisfy the outstanding loan balance. In my previous life, I did third-party collections, believe it or not, and I collected on deficiency judgments. So I know that one pretty well. It's a tough debt to carry. So what distinguishes a lien from other types of encumbrances? It involves a monetary claim against the value of the property. It lowers the value of the property. It is created voluntarily by the property owner. It attaches to the property rather than to the owner of the property. It attaches rather than it involves a monetary claim against the value of the property. Okay, well, yeah, 20 grand or whatever the lien amount is, that's how much is owned by the property. A lien is a creditor's claim against personal or real property as security for a debt of the property owner. If the owner defaults, the lien gives the creditor the right to force the sale of the property to satisfy the debt. Liens do not necessarily alter the property value. Liens can be involuntary as well as voluntary. Finally, liens attach to the property, but so do other encumbrances. So the house is worth 300,000 and you're going to sell it. You might have a lien on it for 250,000 for the mortgage. You might have a mechanic's lien on it for another 10 grand. You might have other liens on it. Those get deducted before you receive any money. If there's an amount due after your amount is put in and there's still an amount due, that's where you get the deficiency judgment. So distinguishes a lien from other encumbrances. It involves a monetary claim against the property. Which of the following best describes an easement in gross? This would be a new one for me. It is a personal right to use land that is attached to an individual and does not benefit any land. It is an easement that automatically transfers with the sale of the property it benefits. It allows a landlocked property access to public road through a neighboring property. It applies to the benefit of one parcel of land over another. It is a personal right to use the land that is attached to an individual and does not benefit any land. An easement in gross benefits a person or company rather than a parcel of land. It is typically used for utilities companies needing access to land for service lines and does not transfer automatically with the land. So easement in gross is the personal right to use land that is attached to an individual and does not own any. Let's simplify this puppy. Easement in gross, personal right to use someone else's land. Benefits a specific person and a company, not the property. Does not transfer when property is sold, meaning that if there is, lines going through there that the company, like they said, the power company needs to get to the lines there. When you sell the property, they still have that access. Utility companies' right to access land for power lines. Yep. So easement in gross just means, just think like, power lines going through and that will always be there. It's a personal right to use land that is attached to an individual and does not benefit the land. It benefits the company or like the utility company, right? All right. An owner transfers title to a property to a buyer in exchange for a motorcycle. This is an example of 1031 exchange. maybe. Uh, hypo, hy, geez, hypothecation, involuntary liquidation, voluntary alienation. Voluntary alienation. Voluntary alienation is an unforced transfer of title by sale or gift from an owner to another party. So we did involuntary alienation, and that was like when the probate court decides what's happening with this. Um, let's simplify voluntary alienation. When an owner voluntary, when an owner willingly gives up their property. So they're alienating themselves from the property, I guess. Involuntary alienation means the court decides whether you're getting the property or who's getting it in their name. I don't know if they have a choice or not, but it sounds like involuntarily they might not. Voluntarily, they have the willingness to give up their property. They can trade it, they can sell it, they can give it as a gift. There's no force or legal requirement involved. Finish quiz. Oh, I didn't do too good on this one. I did 60 on the last one too. So I think I could take this though a second time and probably do a lot better and pass. The test, you need a 70%. I say it's just a pass fail. It doesn't really matter what you get. Pass fail on this. If you guys need individual help on some test questions, want to send something to me, more than happy to talk with you. Again, tryapexagent.com is the website. Ton of stuff on there. My name is Sadler Priest. I'm a 10-year real estate agent. Let me know if I can help.